safe, we stand on guard. We are Canadian, we are free, it's meant to be. From sea to Shannon Sea, we are Canadian.
Hello, Canada. I am Chris Manenboss from Police on Guard, and today I am honored to be joined by the Honorable Brian Peckford. This is a huge privilege and honor, given everything that Brian has done for Canadians since as far back as before I was even born. Brian was the Premier of Newfoundland from March 1979 to April 1989, if I'm not mistaken. Is that correct, Brian?
March to March.
Yeah, there you go. So a full decade. And in that time, he was one of the signatories of the Canadian Charter of Rights and Freedoms. And now here we are, it's 2022, and we see that very same charter is under attack. So we have Brian here to unpack a lot, to address a lot, to give his expert background and experience and opinions on what's happening. And we're just going to start off, Brian, by just letting you introduce yourself and tell us what you want to start us off with knowing.
Yeah, well, fine. Yeah, as you say, I was Premier of Newfoundland and Labrador from March 1979 to March 1989. As a matter of fact, when I got elected leader of the party and automatically Premier at the time, I was interviewed on the in the hall of the Leadership Convention, and I had just won the leadership and just become Premier. And of course, one of the first questions the media had to ask was, how long are you going to stay Premier? I'm elected 5 minutes, 10 minutes. And so you know the way these press work. And so I made the comment at the time, this was March 1979, at the Leadership Convention where I was just elected. And I said, well, I think 10 years would be long enough for any person if in fact the people of that jurisdiction wanted to continue to support me. And sure enough, when the 10 years was up, I never forgot that statement that I made. I tried to get it to the day. But I was unable to book the hotel. It was blocked. And so I was like several days off. But yes, it was from March 1979 to March 1989 that I was Premier of the province of Newfoundland and Labrador. And I was only elected a couple of years when this whole issue of constitution making and patriation of the Constitution, bringing the Constitution home from London for good so that we could have complete sovereignty. Up until 1981, 82, we didn't have complete sovereignty as a country because our Constitution had to be amended in London. And so that's what the patriation was all about. And so it was both the patriation and the Charter of Rights and Freedoms were the two big items, if you will, to try to get solved. And this had been tried for decades. Ever since John Diefenbaker's Bill of Rights in 1960, there had been a move afoot to make that Bill of Rights more comprehensive because the Bill of Rights was only a federal act and therefore only applied to federal jurisdiction and didn't apply therefore to every person in the country. So with that was an impetus to do more and to make something not only a federal act, but in the Constitution, which would therefore, as we thought at the time, and everybody thought at the time and still thinks today, makes it more difficult to change. Well, we know what's happened to that, because if somebody's around to do dictatorial things, laws don't matter. Laws don't matter, and that's what's happened in the circumstances we're in now. And so I was only 2 years into being Premier of the province when this item arose, and there seemed to be a feeling among the 10 first premiers, first ministers, and the Prime Minister that the time was right to try this again. There had been in the 70s a real big push to do this, and there was a conference in Victoria, British Columbia, and it was called like the Victoria Conference, and almost a Victoria formula for patriating the Constitution, because one of the big stumbling blocks to doing that and bringing the Constitution home was the fact you couldn't bring the Constitution home and then say that all future amendments were going to be done in Canada if you didn't have a formula by which it could be changed. I mean, it would be very stupid to patriate a Constitution and not have in it how you're going to change it in the future. It's like, well, don't bring it home until you got yourself settled, straightened away. And so the amending formula became the stumbling block. And in the 70s, when they tried to do this, that was the stumbling block. The provinces and the federal government couldn't find an amending formula. In 1981-82, when we got back at it again, we did find an amending formula, which was 7 provinces and 50% of the population from the last official statistics. And most of the items in the Constitution could be changed by that formula. There were 4 or 5 other ones which needed unanimity, other issues needed unanimity, but the general amending formula was 7 provinces and 50% of the population. And that's what's in the Constitution today, the Constitution Act of 1982. So yeah, so I got really involved in it then. And as you know, we were at it for 17 months. And until we got what we have now, the Charter of Rights and Freedoms, the Constitution Act of 1982. But it all started in those 17 months, 1980-81. And when it was finalized in the fall of 1981, it was called the Patriation Agreement. The next year, it got changed, the words got changed, and people get confused about this, to the Constitution Act of 1982, because it was a bill going to the House of Commons and a bill going to the House of Commons in the United Kingdom. And so this is why it was called the Constitution Act 1982, which included the Charter of Rights and Freedoms, which included an amending formula, which included Aboriginal rights, which included regional economic expansion, which included minority and language rights. And that's one of the other myths that I want to dispel, is that the Charter of Rights and Freedoms wasn't negotiated on its own. This was a bargaining deal. This was a package of things. And so when people say to me, why didn't you have this in? Why didn't you have that in? Why didn't you have something else in? It's as if we were just negotiating the terms of a Charter of Rights and Freedoms. We were not. And so there was a lot of bargaining going on, not only within the Charter, it was a bargaining going on with Aboriginal rights, minority language rights, regional economic expansion, equalization, amending formula, and all of these. So the bargaining was going on with all of these items. For example, the Constitution Act 1982 has 60 items, 34 are the Charter, the rest are the other things. So all of these things, if you look back at history, are deals, right? Are bargains, right? Are vicious negotiating processes, right? Which involve a bunch of things. And this is true in this one. So my argument back to people who say, why didn't you make this better in the Charter, make that, is you don't understand. You know, what we got today is quite magnificent, given that we were bargaining this with a whole bunch of other things, and not just with the Charter terms itself. So when viewed in that light, and viewed that we have freedom of speech, freedom of religion, freedom of conscience, right? Freedom of the press, all in Section 2 of the Charter. We have in Section 6, freedom to move across the country or leave the country, freedom to earn a living anywhere in the country, right? Life, liberty, and the security of the person, equality before the law, right? And the process of going to courts, which has to be fair to everybody. Then it ain't a bad deal.
Well, I would say not. You know, I would say not. And this brings me to my first real hard-hitting question is, as an officer in Ontario, we take an oath to uphold the Constitution and the Charter, which now, based on your explanation, shows how all-encompassing that is, right? It covers all of those parameters that you just stipulated. So that being said, if we don't, as an officer, if we breach the Charter of Rights and Freedoms of, let's say, somebody that we're arresting for, let's say it's domestic assault, and in doing so, we rough the person up and we don't give them the right to call their attorney, right, based on their charter right to do so, the more often than not, that case gets tossed and we end up getting scrutinized. So my question is how is the government getting away with doing this right now? How are they not having their feet held to the fire, and there being massive, judicial processes undergoing right now to address this? Yeah,
exactly. And that is the great question that everybody has. And the only answer I have for it is because the governments are being dictatorial. They're ignoring the Constitution. They're ignoring the very thing that you as an officer and everybody else below the Prime Minister and below the Parliament knows you have to do in the conduct of your law enforcement activities and other people according to. I mean, all the departments and all the governments across Canada very often are told right from the start, you know, as you conduct your business here in this department and that department, make sure and you're going to bring in new amendments to existing legislation, and you want to send it to cabinet, you better make sure you have Justice Department lawyers checking out for whether it conforms with the charter or not. This is common right across the country. And so here you have, in the last 2 years, these governments completely ignoring the very thing that they've been following since 1982. It's like unbelievable. And to show you how unbelievable it all is, just yesterday, I read in the Toronto Sun an article by Senator David Wells, who was a senator from Newfoundland and Labrador, my native province. I didn't know David, but he's now a senator, and he wrote, and it was a good article in the sense that he was taking on the Emergencies Act. And here was a senator coming out publicly in a newspaper, in a large newspaper in Toronto, the Toronto Sun, and saying that how wrong this was. But nowhere in his article did he mention the Charter of Rights and Freedoms. He mentioned in one part of his essay a violation of the Constitution, but he didn't specify that the violations that were happening was with the Charter of Rights and Freedoms and people's individual rights and freedoms. And so here you have it, a senator who thinks he's on the right track. And to the extent that he wrote something, he is on the right track, but was completely incomplete in encompassing what is necessary to encompass the Charter of Rights and Freedoms, which is a special section of the Constitution Act of 1982, detailing the individual rights and freedoms of every single Canadian. And it's amazing. So, and if you look up the commentary that's happened over the last 2 years, outside of people like you and me who see what's going on, more often than not, they're not mentioning the Charter of Rights and Freedoms. And then some who do and think that they're on the right track ignore some of the most important parts. Even the judges who have ruled so far have ignored the first section of the Charter, which is Canada is founded on the principles of the supremacy of God and the rule of law. And there are court decisions today that have not even mentioned that. And by the way, that's the first words of the Charter. Those are the first words of the Charter. And as I remind everybody, at the end of that sentence, there's a grammatical notation called a colon. It's not a period, it's not a comma, it's not a semicolon, it's a colon. Why? Because everything that follows this, everything is subject to this. And it is now, I understand, it has been deliberately ignored because in our secular society, people want to downplay God as a concept, want to really downplay the supremacy of God, and want to downplay that when this is defined, there's only one way to define the supremacy of God. That means that Canadians must have some inalienable rights, natural rights that flow from where? From the supreme being, God. And that's why they want to ignore it, because they don't want to touch what they consider as secularists, right? A religious concept. And then going along with that, they completely ignore, all of this that flows after this has to be consistent with the rule of law. And so
that's in my understanding. Sorry, I didn't mean to cut you off, Brian, but just based on that, so we don't gloss over it, we don't forget, because I wanted to add this. Whether or not you believe in God, to me, is at this point irrelevant because it is still the law of the land. Like in reading anything on the Charter, it is the supreme law of the land. It is what needs to be considered first. And going through the court processes and working as a police officer, how many times I heard through my career that a case got thrown out due to a charter breach violation because the judge determined that we did not uphold the Charter. Not myself. Thankfully, I never had that issue, but others had, and the case was tossed. So therefore, that law, that Charter, the Constitution is still in place.
Exactly. And here's the really, this is what makes it so astounding for you and me to understand. Only in the last 2 months, a female judge in the province of Newfoundland and Labrador had a case come before her, I think it was at the Supreme Court of the province, about a number of people who apparently were involved in drugs, allegedly involved in drugs. So the police were following these people, but they did not follow the procedures under the charter as to the rights of the individuals, and barged into this house or building or whatever it was, and completely ignored the charter rights of these individuals to try to find a cache of drugs. Well, the people involved got a lawyer and took it to court, and the judge threw out the charges against these people because the charter's provisions for proper search and seizure and so were not followed. Meanwhile, it was found that a huge cache of drugs were found in that building.
Because everything
But
after
these
that point is
people got
relevant.
off completely because the police ignored the proper procedure under the charter, and that's what the judge used to throw out the case. So this is only in the last 2 months. Did you see that anywhere in the mainstream media across the country? You would think, given that we're talking with the charter so much, that we're talking with the pandemic and how it's violating the charter, that this would have been front and center in all the major headlines, because here's a judge of a Supreme Court of a province actually throwing out something based completely on the provisions of the Charter of Rights and Freedoms.
And that's incredible to me, because what it tells me is that we have a judicial system that's essentially cherry picking when they want to apply the charter. And that it's incredible, because we've seen over the last 2 years that it's being completely disregarded in one facet, yet in another it's brought into the
Exactly.
charter.
And not only is it being cherry picked, when to use it, when not to use it, even when they're using it, they cherry pick what provisions of the charter they're going to use. Because in the cases of British Columbia and Manitoba, at the trial division of the Supreme Court of those two provinces, they already ruled against the charter and ruled for the two governments. These issues are being appealed to the courts of appeal of both of those provinces, but there is two decisions out there. And in both cases, they ignored the supremacy of God and the rule of law as principles which are going to guide their decision when it's rendered. So the cherry picking goes on of whether or not I'm going to use the charter. The cherry picking goes on even when I use the charter, I'll cherry pick what provisions I use when they don't have the right to do that. The judges don't. They have to apply the charter and all its sections that are applicable to that particular case.
100%. And you know what? I'm going to go ahead and I'm going to address an argument I already see starting to brew in people's minds right now. And that is, well, this is a pandemic. So that's a different set of circumstances. The charter doesn't apply because it's a unique emergency. So to that, I ask you, we all know that Section 33, the notwithstanding clause, says that it has to be demonstrably justified to remove the Charter of Rights and Freedoms from the Canadian public. Has that been done?
2 points. It's Section 1, not Section 33, because Section 3 is not being used at all in the pandemic. Section 63 is a notwithstanding clause where governments can bring in special legislation. They have to go to their legislatures. So 33 has not been an issue in the pandemic. The issue has been with Section 1. So Section 1 of the Charter says that governments can override these rights and freedoms that are defined for individuals in Canada if they can demonstrably justify under law with reasonable limits within a free and democratic society. Now, here's my argument. I have 2 arguments on that. And once again, this gets buried, right? Nobody will carry it. I write it on my blog. I send it out to hundreds and hundreds of people and so on. Here's my 2 arguments, which nobody has been able to effectively rebut. 1, I was there when this was written. I helped write it. Section 1's intent was to be used. This is why it was put in the Constitution. This is why the Bill of Rights wasn't effective. Not only because it didn't cover everybody, right? But it wasn't permanent because it could be changed by any majority government. So by putting it in the Constitution, it's making it more difficult to change. This is why we were putting in the Constitution. So it would be left, couldn't be changed very quickly. So the intent is used in law. Supreme Court of Canada, other judgments have come out where they've used intent. What was the intent of this section? Well, the intent of Section 1 was to be used only in times of great peril, when the state was in peril, when there was an insurrection, when there was a war, when the existence of the state was in peril. That was the intent of Section 1. I was there. That was the intent. Now, go down to Section 4, only 2 sections down in the Charter. And it tells you, it gives you the idea that that's what we were thinking about, because in Section 4, where the Parliament's time might have to be extended beyond 5 years, or for into this war and insurrection kind of situation, you can extend the life of Parliament, but only in a state of war or insurrection or peril to the state. So that was our idea. That was the idea, and it's implanted right there in the Charter itself. So it doesn't even apply in this case, because the pandemic and the virus was is a 99% recovery rate, over 99%, and a fatality rate of less than 1%. That's hardly a condition where the state is in peril. So number one, it does not apply, and therefore what the governments are doing is unconstitutional. Number two, and this is where everybody really gets upset with me and therefore doesn't want to hear me, is this: okay, I'm a reasonable person. I'm a reasonable former First Minister. I've been through the wars. I spent 17 years in politics and 10 years as First Minister. I'm reasonable. I'll take you on that Section 1 does apply, even though I know it doesn't. But I'll take you on, and it does apply. Have the governments met the 4 tests that are in Section 1, demonstrably justified under law, reasonable limits in a fair and democratic, free and democratic society? And if you take the first one and the fourth one, for sure, they categorically, no government in any of its mandates has demonstrably justified what they are doing. Because demonstrably justify means, well, some kind of cost-benefit analysis of your proposal to see whether the benefits outweigh the costs. Nobody in Canada, no government of all of 14 governments has done a cost-benefit analysis. Because you know why? The governments, including Premier Kennedy, who now had to resign, got captured by a very narrow clinical view of society. The clinical view came out of, the Imperial College of London says there are going to be millions dead on the streets, which proved to be wrong, right? University of Washington took over from the Imperial College of London and continued that doomsday scenario, which was proven to be wrong. And now it's been shown that 90 days into the pandemic, the experts knew that the cure was going to be worse than the disease. They knew it. There were numbers coming out that showed it, okay? So even if Section 1 applies, the tests that are necessary to relieve governments of giving everybody their rights and freedoms, continuing to have their rights and freedoms, they never met them. They never met them. And on this fourth one, free and democratic society, a free and democratic society means that in Canada, a parliamentary democracy. We have parliaments, 14 of them. The 3 territories have parliaments too, even though they're not full provinces. So we have 14 legislatures. And what did they do during the pandemic? They opened and closed it as fast as they could, gave themselves more power, and forgot the parliament. In any decent, free and democratic society, like we've done before, we would have a parliamentary committee established, which would oversee and put a check and a balance on what the government was proposing. Is this really necessary? And had public hearings and brought in other experts outside of the government, medical experts, and then had a balance of what was going on, and then would make a report. And they could have done it quickly. Didn't have to be, 5 or 6 months. It could have been done in a few weeks. They could have involved Parliament, and not only involved them for those 2 or 3 weeks, but all the way through the pandemic, to ensure that we were living in a free and democratic society and not ruled by the tyranny of one political party that had a deal with a very minor other political party to stay in power.
And you know what? I'm going to touch on a point you made, because you talked about demonstrably justified. And somebody who's listening to this might say, well, where do you back these assertions that it's 99% plus survival rate and everything else? So I'm going to plug this here now and say that Mr. Peckford and myself were on a conference call the other day that was widely distributed across North America that had a panel of experts from every possible field, and some of the heaviest hitters, and they presented the data. And the one lawyer that joined, Thomas Renz from the US, he also presented data that he was able to quantify through Medicare data that he had subpoenaed. So we talk about what the survival rate is, and you make that assertion here. And I know the naysayers might say, well, that's not accurate. Where do you make that up? Well, we can back that with data. And if you go to policeongguard.ca and watch, you can see for yourself.
And they can go to the Justice Center for Constitutional Freedoms, which are the lawyers who are fighting my case, my federal lawsuit, okay? Go to their site, Canadian, 100% Canadian, not financed by anybody, only individual donors, okay? The Justice Center for Constitutional Freedoms, and go to their research section, and they have tabulated the numbers from every jurisdiction in Canada and showed from government's own numbers, Canadian government's own numbers, over 99% recovery and less than a 1% fatality rate. Our own Canadian numbers.
Well, it's incredible, right? I mean, I hear this and I've seen this. I've seen the data. I've gone through it and I've looked at it for myself to make sure that I'm not way off base speaking at a school looking like an idiot. And going through the data and the numbers, I made quite a clear, concise decision on what I believe to be true because it's their data that I was looking through. So exactly. to that end, you know, I go one layer further and I talk about, you know, there was a recent death report from BC that showed what is killing provincial members of BC, like citizens of BC. And COVID was number 9. And way higher up on that list was liver failure and tobacco use and all that. And why are they not then shutting down the charter to stop the dissemination and distribution of alcohol and cigarettes? Right? If that's what they're after, if they're about saving lives, just one life and everything else we've heard them say, well, to me, it just the weight isn't there, doesn't marry up, doesn't measure up.
Yeah, there's over 40 studies out which show that vitamin D, anybody who had adequate levels of vitamin D in their system, right, were hospitalized less if they got COVID than those who didn't have sufficient levels of vitamin D in their system. Over 40 studies from all over the world just on vitamin D. And they didn't, what government has come up with a program promoting vitamin D? Do you know what I got to do in BC? So, okay, I early on, you know, like you, saw something wrong here. These people are producing this product, but won't stand behind it. No responsibility. Got complete immunity from anything that goes wrong with their product. That was weird to me. I mean, how is that? And then it's experimental. Most vaccines take years to get final approval because of the long-term effects that they got to study. So that really bugged me altogether. But then when I came to vitamin D, I said to my doctor, we want to get a vitamin D test. He said, I guess that would be a good idea. Well, so I could go up to my medical place and get free vaccines, experimental vaccines free. When I went to go and get a vitamin D test, it cost me $65. So that's how crooked our system is, how mixed up our system is. I can get free experimental vaccine, which is now causing all kinds of problems with all kinds of people, but I couldn't get a free vitamin D test, which over decades and decades and decades has proven to be extremely essential for your immunity and for good health. And so there's the dichotomy of it all. There's the hypocrisy of it all. And it just speaks to how tangled up we got early on when this virus came around. I spoke to students last night here in my little city. I was explaining to them that very thing. And I said, I can understand. And I could see the kids sort of nodding to me. I said, let's go back to March 2020, when the Imperial College of London, which was, in most people's mind around the world, was one of the big academic pedestals, right, upon which we, almost pray. That when they came out and said, this new virus that's around, we're going to have millions dying in the street. Well, that's when fear and mass psychosis took over, and it's been running downhill ever since. And nobody's been able to arrest it and say, this was irrational and wrong. And then when the University of Washington took over, and this is what the White House and all of the major governments in the world, Boris Johnson in the UK, Macron in France, all of them in Germany and so on, all looked to was these reports that came out. And so their response was based upon irrational analysis by the Imperial College. So that first 90 days or so when we got into this, it was just all based on irrationality, and that's continued ever since. And the kids sort of understood, the students sort of understood that, and how, because they know themselves in their own, even small, lives that are only 15 or 20 years old, where fear can enter the picture and cause a whole bunch of problems for them when later they find out that this was all based on fear, not based on fact.
Well, and to that end, like one of the things that I've really started to see as a troubling issue in Canada, and this is like monumentally troubling, not just like, peripherally so. Like you see this happening. What I'm speaking to is, we're a democratic country, we're a democratic society, and we see a fear-based narrative that's being pushed out there in the Canadian public. And to those that don't see the counterbalance to it because they haven't heard it, I understand the fear. But where my concern is this. There are so many doctors now that are morally injured from what they have seen happen throughout COVID and the instruction they were given. And then when they asked questions or they spoke out, they were censored and delicensed. And I've heard people say in response, well, they're quack doctors. Okay, you might have 5 quack doctors in any given situation on a federal scale or even a provincial scale. But when you have thousands and thousands of doctors all standing up and speaking up and saying, listen, this is not right. Something's wrong here. We are here on the front lines. We are seeing what's happening. And they get shut down and their licenses are pulled. That should be a shot off the bow for people to go, whoa, what am I being told? Is it true? And do I need to dig deeper? And that's why we're here. And that's why I appreciate this so much, because we need to really get the truth out there for people to make informed consent decisions, because that's not being allowed right now.
Exactly. There just recently 17,000 came out. I put it on my blog last week. There's 17,000 medical professionals and researchers in the medical field who came out all together and said, this has got to stop. 17,000. Credentialed scientists and medical professionals came out and said that. And so you're right. I mean, the data, the big problem you got is not that they're not coming out. And you've got Doctors for Ethics, for example, in Europe, which got members in Canada and the United States. I go into their website all the time, Doctors for Ethics. I go into the Swiss Policy Research, which is another group that are producing all kinds of wonderful, bringing together all the studies from all over the world. Dr. Brian Bridle in Ontario, for example, Dr. Eric Payne in Alberta, Dr. Roger Hodgkinson, Dr. Paul Alexander, who got his work, did all of his, most of his academic work, besides at Oxford, at McMaster University in Hamilton, who was an advisor to who then became an advisor to the White House and is out there on organizations with me right now. Paul Alexander is, and Dr. Hodgkinson, and Dr. Eric Payne, and Dr. Brian Bridle. They're all on a board of advisors of Take Back Your Freedoms, which is an organization that I chair, for example. And so I know all of this data, right? And so you're right. But our problem is this. I call it the 4 horsemen of the apocalypse. I go back to the book of Revelation. It's the 4 horsemen of the apocalypse. Big government, big pharma, big media, big tech. And they have effectively shut down our normal flow of information in a democratic society. And the big media, in this case, they signed the Trusted News Initiative back a year and a half, 2 years ago. CBC was right in the forefront of it. BBC was right in the forefront, Associated Press, all of the main big media organizations. We will not carry anything that's negative to the virus and to the vaccine. That's what they signed. And then the federal government, almost 2 years ago now, announced, after lobbying from the press, that they will contribute to the press to keep them in operation $600 million over 3 years. So all of the newspapers in Canada used to carry my letters from time to time as a former premier commenting upon public policy. Suddenly I was shut down. For 2 years, nobody would carry anything I said. So that's our problem, that even when all of these wonderful independent researchers can come out, they can only get it out on their own websites and through conferences and something like we had yesterday, those kinds of things, where we're on Zoom or on some other independent vehicle, so that we can transmit this information out to the public, because the normal process for transmitting this information has been closed to us.
Oh, it's so true. And I get asked a lot, what can we do about it? Like we get our inbox blown up and people coming to me personally that know me and they say, like, what can we do? What is the best course of action as Canadians to make sure the government is held accountable, the media is held accountable? And, you know, I'm going to ask you that question now because you might have a different approach and spin on it than I do, and my answer's back to them.
Well, I've come to the conclusion, especially in the last 6 months, of watching doctors losing their licenses, watching the political process unfold, that I think, and I wrote about this again this morning. Since I got up this morning, I have stuff in my head. I wake up and I have this stuff in my head, and I read a new press thing. And I'm sort of convinced now the first thing we've got to do is we got to clean up the political parties. Because how can we support a political party if they themselves are not clean? Now, right now, those parties that are in the House of Commons, those major English language parties, if you will, I'm not going to deal with the Quebec party because I think they're there unconstitutionally anyway, because they never signed on to the Constitution Act of 1982. So I'm only going to deal with the parties that are in English Canada, and also they campaign in French Canada as well. So there's the Liberal Party, the Conservative Party, the NDP Party, and the Green Party. Okay, not one of those parties publishes their financial statements on their party website. Any member of the Conservative Party, Liberal Party, NDP Party, Green Party do not know where their money goes when they contribute to these parties. There's no audited financial statements produced. I've been writing about this now for about 3 months. And of course, it's hard to get any like this published. So I go right back to basics. So if the people that we are supporting, who are going to be our government in the future, are not producing their own financial statements, how can we trust them, right? How can we trust them to manage our tax money when they form the government? And so there's a basic problem here. Okay, that's number one. Okay, number two, the Prime Minister of Canada today has broken the law 5 times, and yet he can still sit in the Parliament of Canada. One would think that some MP somewhere from some party or some independent TV, but particularly the parties themselves, would propose a resolution in the House of Commons saying any MP who breaks the laws that we're creating cannot sit in the Parliament. Wouldn't that be a wonderful thing to happen? Most Canadians think that's automatic now. It's not. It's not. Prime Minister is Exhibit A. He's sitting in the Parliament after breaking the law 5 times. And so, and that's conclusive. That's not hearsay. That's the Ethics and Conflict Commissioner's report, independent report, that's out there for anybody to read on the website of the Conflict of Interest, okay, Ethics Commissioner's website. And nobody has challenged it as being not factual and true. The law, the Conflict of Interest law has been broken 5 times by our Prime Minister. And Mr. Morneau, when he was Finance Minister, he broke the law too, because he didn't disclose an estate that he had in France when he was supposed to. And his argument was he forgot about it, or he didn't know that that was necessary. But he did, because he did disclose other financial assets. So, you know, he was lying. So that's number 2. So we've got to clean up that an MP in Ottawa and in the provinces, the MLAs and MPPs as well, cannot sit and become an MP if they've broken the law that they were supposed to be adhering to and creating in their parliaments. So those are 2 things that could be done right now. We clean up the political parties where there is, under the Elections Act or under some relevant legislation, a requirement under law that every registered political party in Canada has to produce annually audited financial statements of their entity, of their organization. Then we know where they spent the money. Then we can decide whether we're going to support this party or the other party based upon how transparent and accountable they are. So those are two things, right? MP can't serve. So we got to go back to basics and clean up our political parties. Then we've got to clean up. So this is the third thing we got to do. We got to bring power back to the parliaments in Toronto, in Ottawa, in St. John's, in Victoria, Edmonton, Iqaluit, wherever there's a regional parliament. They all must be cleaned up so that the parliament has power again, not the Premier's office, not the Prime Minister's office. And this can be done without a shot being fired and without a new law being passed, because it's already on the books. The Prime Minister's office is not supposed to have the power that they are exerting today. When Jody Wilson-Raybould was Minister of Justice and Attorney General, right? What happened to her? The Prime Minister's office interfered in the course of obstructing justice. That's one of the laws that the Prime Minister broke. He tried, and his office tried to obstruct justice. The Justice Department had already decided that SNC-Lavalin should go to court because they had sufficient evidence that court was warranted. And they had made that decision. The Prime Minister in his office and other ministers tried to get that changed where we do an out-of-court settlement with SNC-Lavalin, and they wouldn't be brought to court, okay? So he had to back away because that was exposed. And then the parliamentary committee was formed to review it. And the parliamentary committee closed down when Jody Wilson-Raybould still had information she wanted to disclose at the parliamentary committee. And who closed it down? Because it was the tyranny of the majority. Majority of Liberal MPs and NDPs closed it down because they had the majority on the committee. Now, here's what can be done very simply, is that parliamentary committees, right, cannot be shut down by the majority if the witnesses that are appearing before them are credible and have additional information to present, especially when it's information critical to the pursuit of justice in our country. So you'd have conditions under where you could and could not override the majority, but the facts themselves will decide whether in fact that is true or not. So the parliamentary committee got to get its power back. The MP got to get this power back. You go to an MP today and say, I want you to put this resolution on the order paper. He'll come back, he or she will come back to you and say, well, the list is so long now, 3 years from now. I tried that, by the way. I know that to be a fact because I went to an MP and asked them in writing, okay, 3 years before they even get a private member's resolution because it's so backed up. We have to clean up Parliament so that MPs have an opportunity in a timely fashion within the term of that Parliament to present resolutions so we got to be more efficient, right? Within our Parliament.
How do we make that happen? How do we make that happen? That's my question.
Parliament itself can make that happen. Parliament itself has to do that. So the citizens have to put pressure upon their MPs, upon their parties to see these changes happen. One, no MP can serve if they've broken the law, if they have been found guilty of breaking the law in the due course of process of our court system. If you've been charged, if the ethics or the conflict of interest commissioner has ruled that you've broken the law, then you cannot serve. You cannot serve. Because there's no penalties there right now, see? There's a conflict of interest law, but there's no penalties if you break it for an MP. So what's the good of the law if there's no penalties there? So people say, well, we got a conflict of interest law, but we're a modern democracy. Yes, but where are the penalties if you break it? I think it's $100. The Prime Minister it's just a fine up to $1,000. So I mean, so these are the kinds of fundamentals that Canadians have missed over the years, right? We've become complacent and allowed the Parliament power to move from the Parliament itself to the Cabinet and then to the Prime Minister's office. If you try to find out tomorrow how many people work for the Prime Minister's office, you would have a job to find it. I did it for quite a few days and weeks, and it comes out to right now about 1,500 to 1,600. Just reporting to the Prime Minister of Canada, even though he has 7,000 deputy ministers and assistant deputy ministers and other like people that he appoints directly. He already has 7,000 that he appoints directly and therefore can hire or fire and therefore report to him in that sense. And now he needs another 1,500, 1,600 that report directly to him in the Privy Council office and the Prime Minister's office. Crazy. So what has happened, and you know this, if you talk to any minister in Ottawa today on a private basis or an MP or parliamentary secretary, they'll tell you nothing happens unless they check the Prime Minister's office, even cabinet committees. Now, one time in Canada, and it might be even in your lifetime, there were very strong regional ministers. If you look back in the recent history, and really strong ministers, Remember Jean Chrétien, Marc Lalonde, right, from Quebec, and there were 4 or 5 other really strong ministers. There was Alan McKechnie from Nova Scotia years ago, John Crosbie from Newfoundland, Don Mazinkowski from Alberta, Lloyd Axworthy from Manitoba, right? You can go on and on. These are the ones that just come to mind now. They were strong regional ministers. They're gone. You can't point to any regional minister now from Ontario or Quebec or anything that has any power. It's all concentrated in the Prime Minister's office. That's why he has 1,500 people working for him directly, besides all these deputy ministers. So we can tomorrow, if we really want to, but you really got, you know, you can talk the talk, but you got to walk the walk. And that's what's happening. People are talking the talk, but they're not walking the walk and saying, I know enough about my political system that we can change a lot of it without a shot being fired and without even very much change to our existing legislation. Just enforce what we already have. Change the conflict of interest law, yes. It's already there, amended so that the penalties fit the crime. So that people who are MPs, who we're supposed to look up to, are not allowed to sit in that parliament if they've broken our laws, right?
So would you think that to be the first and most important step? And would that be something an MP could bring forward as a bill to have? Okay.
Yes. Yes.
So that being said, so here's my call to action then for anybody that's watching and potentially even an MP who might realize that something is not right here and you're wondering what it is you can do. You heard it from the Honorable Brian Peckford himself here. Bring forward a bill. Bring forward a bill to have that amended in the House so that we can bring forward the change that we're discussing here, so that there is an actual consequence for going forward and committing criminal offenses or any offenses while holding the seat of an MP or a prime minister. And people, Canadians, my fellow brothers and sisters, hearing this now, get on the horn with your MPs, get active. This isn't about violence. They try to paint the convoys and all these things as violent insurrections and this nonsense. The reality is people move the needle. Get on the horn, make your voices heard. That's democracy.
And go to your political party that you support and say to whoever your local president of your district association is, riding association, get on the horn and tell them, I want to see the financial statements of my party. I'm contributing to it every year and I don't know where my money is going. Show me the audited financial statements for our party. Please, please. This is democracy. So there's 2 things that any citizen of Canada can do, no matter where they live. Go to your local provincial party, go to your local MP and federal party and ask them those questions and say, I want you to put a bill in that no MP or MLA or MPP can serve in the parliament, that they've broken the law, the conflict of interest law, or any other law of Canada, right? And 2, I want to see the financial statements to my political party that I support. There's 2 things that any Canadian can do today.
And you know what? That's incredible because we get asked the question all the time, and I have limited scope. I'm a police officer, got hired in 2005, and my career is wrapping up as we speak, and that's fine. But people ask me, what is it that we can do? What is it we can do? Well, there you go. There are 2 things. Together as Canadians, if everybody that knows what's going on right now decided to act on those 2 things, we could move the needle. We could affect the change we need to happen now in this country to save it and bring it back to the 1980 foundational principles that our Constitution and the Charter were based on.
Right, no question. And without any protest, without anything, you can just do them automatically through your own local constituency association and with your own local MP. And you know, and I know, and Canadians know, that if enough people got mobilized and this became a bit of a movement, here's 2 things we can do. Party-wise, we can transparency. You want transparency and accountability? There's 2 ways you can do it. With the political parties, produce your financial statements every year. Your audited financial statements every year. 2, change the conflict of interest law so anybody who breaks any Canadian law cannot serve in Parliament. Wouldn't that go a long ways to giving accountability and transparency and people beginning to trust the system that now everybody knows cynically is not working? Those 2 things alone could go a long ways to making a difference in how we're governed.
Well, Brian, I'm going to say this to you. If we can make this happen and we're able to affect this positive change in this country, I'm gonna fly out to where you are, and we're gonna have a big celebratory hug and maybe cheers a beer or two, and we're gonna celebrate getting this nation back on track. Because I'll tell you, it's been pretty daunting seeing what's happened in this country,
Yeah.
and it's really worried me of the direction it's going to continue to go in if we don't step up and step in and do something about it. And I'm just so proud that you are, and I'm able to do it with you.
Last September, October, I proposed, as a former First Minister, knowing that this was legal, that every First Minister, every Premier and the Prime Minister, if they're so confident that their pandemic measures are constitutional, refer those pandemic measures to their highest court. And it's called the reference procedure. And I wrote every Premier and the Prime Minister and said, will you refer your pandemic measures to your highest court and get a constitutional opinion from your highest court in your jurisdiction? Not one of them agreed to do it.
Well,
wouldn't cost them a cent. Just refer to your highest court, who are there working and getting paid every day. And by the way, if a reference procedure was done, the court would drop the other priorities they had of hearings to come up, because here is the government, right? Here is the government of my jurisdiction asking me for a constitutional reference, and they could do that within a month. Not one First Minister would do it, and I couldn't get that covered nationally in the mainstream press.
Well,
That's
I have a feeling that it's going to change, though, Brian, because I can tell you the tides seem to be changing. The temperature of this country is changing. People are fed up with having their voices just silenced and their livelihoods being taken away, their very quality of life being disintegrated from underneath them. And people are wanting to know what to do. And we, as police on guard, we've always been trying to find a democratic, peaceful way to bring about a resolution. So having this conversation with you today was paramount for us, because I wanted to pick your brain. I wanted to know from the guy that was a part of crafting the most important document in Canadian history. What can we do? What can Canadians do? How can we work together? Let's do this.
And the other thing I'm doing is, rather than just talk the talk, I knew at some point doing all these meetings and all these Zoom meetings and public meetings on Vancouver Island, where I live, and getting involved, nationally with other organizations and so on. I knew I had to do something more, because somebody could stand up either on a Zoom call or in one of my live public meetings and say, Brian, Mr. Peckford, that is wonderful. You're very articulate. You know what you're talking about. There's no question about that. You reference everything. You just don't go off the handle. And I knew somebody's going to say, why don't you walk the walk? And so I initiated a lawsuit against the federal government on their travel ban. And so my court case is ongoing right now. It's in the courts as we speak, in the Federal Court of Canada. The hearing is going to be in September. It's set. And the lawyers are now fighting in the courts over the data that we're presenting, and we're fighting the data that they're presenting. That's sort of the case management part of the thing. So it's live, underway in court, and will be heard September of this year. And so likely we'll have a decision before Christmas on whether, in fact, that federal mandate to stop me from traveling in my own country, the only Western nation, by the way, right now, only Western industrialized nation that has any kind of travel ban like this in place, just Canada. So I can't travel on plane, I can't travel on train, right? And so I am I'm prevented from going and seeing family in Ontario, in Nova Scotia, in Newfoundland, or whatever. And businesses are presented. Now, I have 5 other people who felt really strongly about this from across the country who were on my lawsuit as well, all with individual stories to tell about how they're negatively impacted by the federal mandate. And they're part of my lawsuit as well. Meanwhile, and Maxime Bernier, leader of the People's Party of Canada, is also part of the same lawsuit. Because remember, the only party leader in Canada who stood up for Canadians during this pandemic and who went to jail was Maxime Bernier. Nobody else. The only person who walked the walk was Maxime Bernier. And he's part of the whole lawsuit as well. So what we did was, it's very important for your listeners and the people who are watching to understand, is that we were successful in combining all those people across the country. There were people in Ontario who had gone to lawyers there, and in Quebec. We contacted them because we knew they were going to initiate the same kind of lawsuit against the federal travel mandate. So if you've got 5 or 6 going at the same time, that's going to piss off the judge. I mean, I got to hear this 5 times. And so what the judge will do, will unilaterally, and they have the power to combine all of those. Let's not let the judge combine them the way he wants to combine them. Let us combine them before we go. So when we go, we've got one big super punch together. And that's what we did. So the lawsuit now that's underway, my name is on it. There's other names on it as well. Because I was a former premier, of course, mine gets profiled. But there are other people, beautiful, wonderful, loyal Canadians on that lawsuit as well, who are fighting what's going on. And so I want you to know, and I want your viewers to know, that we're walking the walk and we're moving this through the system. It's been accepted. Lawyers are appointed by the federal government to fight their side. My lawyers on our side, the Justice Center for Constitutional Freedoms, and they've actually hired an outside lawyer to help us on it, Keith Wilson, who was also the lawyer for the Truckers' Convoy. And he is the lead lawyer on this lawsuit that I and others have initiated. So come September, there will be a hearing of 5 days. And then the judge goes away with all the data that's been fought over for the last 5 or 6 months and comes up with a decision, hopefully before Christmas. And so that may be the first big case to test the mandates that governments have brought in.
Well, between the recommendations you've made for Canadians on how to effectively change what's going on in our country for the better, as well as hearing about this court case and those that are working with you, I just want to say one thing, and that is thank you. Thank you from the bottom of my heart. And I know I represent a lot of Canadian folks in saying that. And all I'm asking you now before we go, if you can, is do you have a message of hope for Canadians who feel like all is lost? Is there something you want to say to them before we end this interview?
Well, I think what I've said in the last 10 or 15 minutes manifests and crystallizes what each Canadian can do, either through the courts with others to challenge what's happened, or through the political party process. Go to your political party, make it more transparent, make it more accountable. Go to your MPs and MLAs and tell them to pass laws, very simple, amendment to the existing conflict of interest legislation, which is in every province and in the federal government, to make sure that MPs, when elected, are not people who can break the law and still allegedly serve my best interests as a citizen of this country. So that's the hope we have. The hope lies with us in initiating change.
Amen, brother. I couldn't agree with you more, because as the saying says, a nation divided cannot stand, right? And
exactly.
Stand together or we're all going to fall.
We can make change if we really, 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 really want to.
I agree with that. I agree with that. And I got to thank you again for coming on and for relaying all that information and just being such a valuable resource to not just Police on Guard and ourselves, but the rest of Canada that's watching and tuning in. God bless you, brother. Let's keep in touch. You need anything, you let me know and I'll do whatever I can to help you.
We are Canadians, stand tall.